All right, can you guys hear me now? Yeah, that's what I did. I just went out and started over, but can you hear me now? I like Little Red's comment. Hoe out and start over, maybe. Okay, good. Okay. All right, let's try this again. Okay, how about that? Um, okay, so just to update you guys, I did make it to Texas safe and sound, but what a drive. Driving from Florida to Texas is no joke. And I'm not even the one who drove. My husband is the one who did the driving because um he just likes to do um the driving or whatever, he's just not, it is what it is. He doesn't really have a whole lot of faith in me. Plus, it was like one of those big trucks, moving trucks or whatever. So he's like, let me just do it. And I was like, all right. Yeah, that's right, Allie. Put that in the chat. Ho out. It's so good to see you guys. I've missed you so, so much. Yeah, Allie, I just kind of decided to do it impromptu and see where we go. Hope it works. So yeah, we made it safe and sound. I got to see my little Livy chicken nugget pot pie, and oh my gosh, you guys, I'm so crazy about her. She's just the absolute, absolute best. But yeah, so I know that, and the not so wicked stepmother. Welcome back. It's been a long time. Um, so I'm glad to see everybody. I think it's just I need to get a remember when I at the old house when I first got my desktop we were having issues. It's because the little thingy that picks up the Wi-Fi is not very good. I need to get a new one, but um, I also think that the better play, if I'm going to spend the money, is to get um, which I already have. I have the thing that is the splitter, but I think that I don't know that 20 feet is enough. So, yeah, but other than that, listen, I could still use a little bit of help if anybody wants to. I'm gonna put my I hate doing this. I feel so gross doing this and I'm so sorry. I'm gonna put my links in the chat for you guys if you want to tip your hostess. But yes, I wrote supports. Okay, that's probably not going to work. Because I was talking while I was typing. Here we go. That'll work. Supports. It's good to see everybody. I'm so glad you guys are here. I've missed you guys so much. I miss streaming. Listen, before I forget, there's a couple of things, and I just kind of feel like doing it tonight. So I'm going to do it. I'll change the thumbnail and update everything after the stream ends. But not only has the chat informed me, but KPM sent me an email to let me know that the unredacted, unedited version of Sarah Boone's speech has been uploaded. So I absolutely want to get to Lori. But so let's do that first because that's really the live that you guys came to see. So let's start with Lori and then let's hear Sarah's, y'all, 28 pages. 28 pages. 28 pages. Boone, Boone, Boone. Also, while I was driving from Florida to Texas, Little Red, you're so sweet. While I was driving from Florida to Texas, I don't want to say driving because that feels like I actually did something. Mainly my job was to keep the driver awake. I was the co-pilot. Um, I don't know how to edit it in the I can edit it on YouTube. So that's what I'll do, Allie. That's a good idea. What I'll do is I'll start, and while I'm playing Lori, I'll go over to the studio and edit the title. Will that work? That should be good. So I will, that's right. So I will, I'll do that. Okay. So, but while I was writing, I was checking as often as I could to see if Florida has transferred Sarah. And I didn't try yesterday or the day before, Monday or Tuesday, but I definitely will check again. Also, for those of you guys who were here for, oh, thank you, Victoria Lee. I appreciate that. For those of you guys who were here and followed the Chloe Driver trial, her sentencing is tomorrow at 9 a.m. Okay. I don't give a rat's fat kneecap if I have to wear tinfoil on all 10 fingers and toes on my head and stand perpendicular to the equator. I don't care how it has to happen. I will be streaming that sentencing. I want to hear who speaks for her, and I want to see what she's going to get, because she was found not guilty but mentally ill, which doesn't mean it's not a real win for either side, right? It's a compromise. She didn't get not guilty by reason of insanity, which is what she wanted, right? Which means she would have spent her sentence in a mental institution, a prison run mental institution. She just, wouldn't be out and then, or with what the state wanted, which the state was like, no, just put her in prison for however long. I guess they're going to do their recommendations or whatever. So that's what we got going there. So that'll be tomorrow at 9 a.m. Georgia time, which means that's 8 a.m. Texas time. So yeah, so that's what we'll do. All right, so let me share my screen and let's get into this situation with Lori, because girl, she doing too damn much. Let me say this, Lori. I don't understand how it is that you think it's a good idea. I mean, you're a murderer. You are a monster. And now you want to add lawyer to your resume? Whatever, Lori. Just all right. Here we go. Let's play this, and I'll go over to the StreamYard, or I'll go over to YouTube and change the title, and then we'll read Boone. All right, here we go.
Oh, do you want to set the podium?
Good morning. If you're the victim of a crime with a case pending before this court, you're advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay, we're ready to go on the record now in calendar number 1 and 2. This is CR 2022-001-242-001 and CR 2021-001-704-001. Matters of the State of Arizona versus Lori Vallow have appearances.
Good morning, Your Honor. Katie Staub appearing for the state.
Morning.
Good morning. Our Pamela Hicks and Robert Abernathy on behalf of Ms. Lori Vallow Daybell, who's present and in custody.
Thank you. Ma'am, tell me your full name and date of birth for the record.
Lori Daybell, 6/26/1973.
Thank you. All right, so last we were here, we were waiting on a second report from Dr. Hernandez. Since that time, Dr. Hernandez has been relieved. The court's appointed Dr. Webster. Dr. Webster has met with the defendant and submitted a report dated December 2nd, 2024. So we do have two reports. My understanding from the state is that there's some issue, though, with the redactions that were made to that report. Did you want to be heard on that, Ms. Staub?
Just briefly, I did send an email to the court and to defense counsel yesterday, just indicating upon review, the state's review of the most recent report, it seems like there were a lot of redactions made, most concerning in the opinion of the doctor. So I just wanted the court to have an opportunity to review that and assess basically whether those redactions were appropriate.
Okay. So redaction of Rule 11 reports is dictated by Rule 11.4A2. Redactions are allowed for any statements by the defendant about the charged offense or any other charged or uncharged offense or any summary of such offense. I read that to be very broad, but I don't read that to include anything outside of statements about those things. Did you wish to be heard on redactions?
No, I'm just looking, and if it's, and I did not bring my laptop, but I have my highlighted copy here, and if it says to section 4, the opinion as to competency, I had some things that I talked to my team about whether or not they were questionable, but I don't think I redacted, but the court can correct me if I'm wrong.
The state provided the court a copy of what they've received, and it does have a redaction here under the 4th section in the clinical formation on page 5 of the report. So it's that last sentence of the first paragraph there.
Oh, I think that was just because it was relating, it wasn't necessarily a statement, but the comment was relating to Idaho.
Okay. And I recognize a lot of the statements and information within Rule 11 proceedings might be concerning. There are certainly protections by law to prevent those from coming in as evidence at trial. And so rest assured that this information is not going to, unless it falls under limited exceptions, it's not going to bleed into any trial stages of the case. But from my reading of what's been redacted, I'm not sure that it falls within that rule. So how do we want to proceed?
It's that last sentence, correct?
Last sentence of the first paragraph under clinical formation.
I'm fine with just reading it.
Okay, so we can actually print out that last page and provide it to the state with the defense's permission.
That's fine. Or should I just show it to her?
And I just want to be clear for the record. Your Honor has reviewed the other redactions and finds them appropriate.
Okay, I'm not sure that this is the one that I wanted because I'm looking for the one where, hold on, let me see if this is it. Let me just look. Yeah, no, I guess this is it because this is the one where I guess he's going to speak to her. So I guess maybe the way that it's going to be, I guess I just missed it, but or it's not there yet. But first of all, I cannot imagine a scenario under which I don't understand what she's trying to do. Okay. Because when you do something like this, when you have court-appointed attorneys or even a private attorney, when you have an attorney representing you in a trial, and you say, you know what, stop. I don't want to be represented by an attorney. I want to represent myself. Okay. What you do then is you essentially waive rights, and the judge is going to explain this, but you do waive your rights to certain appellate issues, specifically the right to appeal based on ineffective assistance of counsel. And even if I understood the judge correctly, let's say Lori then goes forward and she starts handling, her case. Sorry, I got distracted for a second. So whenever so let's say Lori is midway through the trial. okay, through her trials. And she decides, I think I should have standby counsel represent me. He's not, you can't go back and forth, but I believe then too, she waives, the way that I understood it, she waives her right to an ineffective assistance of counsel appeal as well. And I think that Melissa Alex says it isn't about her being limited to appeals in the future. It's all the extras, the delays to get things done because she's restricted. Yeah, I mean, I think Lori is pulling some shenanigans. Okay. I think Lori's pulling shenanigans in the exact same way that we've seen it happen before, like with Letitia. I think what she really wants is to have unfettered, unrestricted access to her discovery, to see what's in there. That's honestly, for just a regular person who does not have any education in the field of law at all. Like, we're not, no paralegal experience, never worked as like even a secretary for a law firm. I cover trials all the time. There is no scenario under which I would ever, ever, ever haul my cookies into a courtroom and think that I could represent myself. I wouldn't even represent myself on a speeding ticket, for Pete's sake, or any other ticket for that matter. No, absolutely not. This is the only benefit I can see to doing that for just a regular everyday person, is that they want to get their paws on the discovery. And I don't think that she should be, I mean, obviously, yes, she's limited because of her restrictions, because she's currently incarcerated. But I don't think that the judge should extend her a whole lot of grace when it comes to what delays he's going to allow and not allow. All right, here we go.
That was the clinical formulation was the most concerning part to the state, but because we usually don't see that extensive of redactions, I just wanted to be sure that, and that's fine if the court has made the evaluation that those are appropriate. I just want that to be clear on the record.
I also kind of wonder if Lori's going to testify in this one, but just while we wait for them to kind of shuffle papers.
Ms. Hicks, do these other statements, are you wanting to lift redactions of these other statements as well based on what we've discussed this morning?
So
I need to
section
fix this.
3, the family and
Yes,
social
little red.
information.
Hold on.
Those statements kind of.
So Lil Red says, isn't that how Legrecia started out? Yes. So initially, right, she was represented. She requested a conflict hearing. Judge Werner granted the conflict hearing. It was overheard by another judge, and overheard. It was heard by another judge, and that judge deemed her competent to represent herself. So that's when she represented herself, and she was pro se for a few months. And then she ended up getting Josh Tellini, which was her standby counsel. She said, I don't think I want to be pro se anymore. She got Josh Tellini, who was already her standby counsel. He stepped in and became her attorney of record. And then they changed her plea from not guilty to not guilty by reason of insanity. And so, yeah. What I learned, though, is, so remember how when Sarah Boone, like, this was so long ago, but it does feel like a long time ago. Remember how Sarah Boone, when she was pro se, we were wondering, like, how she will be, how it is that she's going to be able to testify. Okay. So what I learned in this courtroom, I don't know if this applies to all courtrooms or all cases, but the judge made a ruling on this one. And the way that I understood it is, it's not like Lori can just take the stand and just start talking. She's not going to be able to give a narrative. So what happens is, what Lori will do is she is supposed to write out her questions for herself, and her standby counsel will ask the questions. And then, of course, she's subject to cross-examination. Okay.
Deal with the arrest when she was arrested. So, and we're being cautious in this case, given the unique circumstances of it.
How about the other statements?
Oh, sorry. The one in the history, the victimization history, we're standing by that redaction. We wouldn't, I don't know how to phrase this, but it gave us some concern that potentially could be issues in a trial. I'll just leave it at
But
that.
how is it a statement of a charged or uncharged offense under the rule?
Again, I'm pretty new to this case. I think if I'm correct as to what happened in Idaho, there may have been, plus can we maybe approach?
You may.
Because
Okay, so to be clear, and we're back.
All
on
right,
the record,
let's
thank
see.
you. To be clear then, in terms of what the rule permits for redaction, the court is allowing redaction, as counsel indicated, in terms of some language about an arrest and extradition, but other redactions do not appear to fit underneath Rule 11.4, and so should be lifted. So the state has a chance to review that. It's just a few sentences in a brief report, and so I hope that the state can do that and we can proceed this morning to prevent any further delay. Is that something we can do?
yes, Your Honor.
Okay.
And the state doesn't need to review all the redactions in order to stipulate. For the purposes of the record and so that we have the unredacted copy, if defense counsel can get that to us as soon as possible, we can still proceed today.
All right. So with that, are the parties prepared or willing to stipulate to the two mental health expert reports?
So I just want to make sure I will provide a copy where we can leave in the redaction on page 2, take out the other redaction, send that to the state, and then move forward. Yeah,
That's correct.
okay. And as far as stipulating a competency, just
Oh.
so that the record is clear, because again, we
Hang
have
on just a
filed to
second,
get
I
out
noticed
here, we're
something.
here because the court.
So when Lori turned her face just a second ago, is it just my imagination? Or are we back to the hot Cheeto dust lipstick rouge combo? You guys tell me. I'm kind of curious. I feel like we might be, but I'm not sure.
Court placed her placed her in Rule 11 on its own motion. That's why we didn't fill out the form and have that prepared.
Right.
We do agree that there's 2 competent reports and would like to move forward, and we just as defense don't necessarily want to technically stipulate, but we will. Does that make sense?
Not really, no. Because there's really only 2 avenues here to proceed.
I'm always on the
You can
lookout for that. We
contest
gobshite
that
always.
She's competent, and we can have an evidentiary hearing, and you can present your evidence, or the parties can stipulate to the reports which do find her competent.
Let me just say this. We are willing to stipulate. It's just we want the record to be clear that we're here on the court's motion and not a defense motion. But we are stipulating the competency so we can move forward.
Right. But nothing in filling out a stipulation form would reflect that you're here on your own motion, or that you agree with being in Rule 11. So that would be how I would suggest we proceed. Is that something defense is willing to do? All right. We've got stipulation forms in front of you in that basket right there. And so you can fill that out. The state's agreeing to stipulate to the reports.
Oh, what a
Okay.
organized courtroom. I
The court
love that.
is not yet in receipt, but will be in receipt of a stipulation as to the defendant's competency based on the written reports here by Dr. McGady, dated November 7th, 2024. Dr. Webster, dated December 2nd, 2024. Stipulation having been accepted, the reports having been considered, the court finds the defendant understands the proceedings, is able to assist counsel in her defense. The court further finds the defendant competent pursuant to statute. It is ordered affirming prior release conditions, and we'll get you a new date in front of Judge Boreski so you can proceed in your case.
Okay, so to answer Amy J. all day, yes. Yes, she is a new attorney. She is. I mean, like, she's been practicing for a while. She is new to representing Lori Vallow Daybell. So, yes. All right, here we go.
Judge Boreski indicated he can get you in tomorrow at the earliest at 8:30 or 9 a.m. Does that work for counsel?
Yes, Your Honor.
Okay,
Okay,
so
this
I'm
is not the one
remitting
I
this matter
wanted,
to
I
Judge
don't think.
Boreski's division. We'll set it as a status conference tomorrow. That's December 6th at 8:30 a.m.
All right, let me find the other
Anything
one.
further?
Oh, yeah. Not, Your Honor, can we just have a moment to make sure that that works for the victims and
Oh,
next of kin?
absolutely. Yeah, thank you.
I think that's it. Oh, hold on. Let me see if they show Lori.
Thank you. We're adjourned.
Thank you, Judge.
Thank you, Judge.
Yeah, what are you doing, camera guy? Can't tell.
You guys gonna send that today? Yes.
All right, give me just a second and I'll get the other one. So here's what I think about all of this. All right. Sanity and competency are not the same thing. Let me just hold on a second. I think this is the one I want. Yeah. Is this it? Let me see. Hold on. Bruh. I really don't appreciate you doing that, YouTube. Okay. This is the one I want. Now, I will tell you guys right now, I'm going to have to return to using the golf voice, the golf announcer voice, because the audio in this one isn't that great. But I do have the closed captions turned on. All right. So just quickly to sort of talk about what we just heard. All right. The deal is competency and sanity are two very different things. Okay. When somebody is deemed competent to stand trial, the bar for being competent to stand trial is not a very high bar. Okay. Basically, in a nutshell, what Lori, in order to be found competent to stand trial, Lori must A, understand the charges against her. Okay. She must be able to assist in her defense, and she must be able to understand the courtroom setting, like who the judge is, who the jury is, the lawyers, both the state and the defense, and understand what their basic function is. That's really, hey, Carolina, good to see you, babe. That's really all that's required for her to be able to be found competent to stand trial, which is interesting to me given what happened in Idaho. So it sort of makes you wonder, was Lori always competent to stand trial in Idaho? And did she malinger or feign? Or is she, or were those findings correct and she was not competent to stand trial until they took her to like competency camp and then tried again, and then she became competent to stand trial, or what the deal was? Because it kind of does make me wonder, about Lori. Like what's the real truth? Which I don't think we're ever really going to get it. Oh no, Boone's Boone's Toilet Hooch. We're going to listen to the last of Lori and hear what the judge says in this hearing, and then I'm going to get to Boone. Boone was kind of an addition. I wasn't. I got an email last minute, and so I want to share it with you guys. I mean, look, we've been through a lot with Sarah Boone, and we need to. And whatever happens, we're going to go through it together from this point forward. So here we go. Oh, what was that about? Yeah, it's a little Boone bonus. Woohoo! All right, here we go. Let me just skip forward. Oh, I guess I need to push play.
Pamela Hicks and Robert Abernathy on behalf of Lori Vallow Daybell, who's present and in custody.
Ma'am, can you tell me your name and date of birth, please?
Lori Daybell, 6/26/1973.
All right, thank you. We're here for a status conference. You've been found competent by two separate healthcare providers. Is it your intention, ma'am, you had expressed earlier that you would like to represent yourself?
Yes, sir.
Is that still your intention?
Yes, Your Honor.
All right.
I may approach, Your Honor.
You do understand that you have the right to have attorneys represent you during your cases?
I do.
What grade did you finish in school?
I graduated from high school.
Do you read and understand English?
I do.
Have you had any drugs, alcohol, or medication in the last 24 hours?
No.
Okay. Thank you so much. Always. Oh my God, a one-way street. I cannot speak today. Whatever those notifications are, I can't see them. So did somebody gift memberships or something? Because, oh, you were Trace on the case? Wow. If you did, I don't know what those, it's not coming through for me. So whatever that is, thank you, thank you, thank you. I appreciate it very, very much. I forgot what I was going to say. Oh, well. Okay, I know what I was going to say before this. First of all, I see that Lori is back to what I refer to as, remember the Cowardly Lion from The Wizard of Oz? After they got to Oz, okay, and they all got their hairs did and new outfits and all the things, and the Cowardly Lion had his hair up in that little ponytail with the red bow at the top, the half ponytail. That's what she looks like here to me. Only this time, I think she's chosen to wear it on the side, which that's a bold choice. You know, you do, you, boo. But I will say this. So Lori was asked if she's on any medication. Okay. And I've wondered about this for a very long time because I personally do think that Lori is sane. I think that she has some mental health issues, but I do think that she is sane. And I'm kind of I need to, this is not going to work. This where the microphone is sitting. It's not going to work. It's not comfortable. I keep hitting my head on it. And you guys can hear it. I'm not sure exactly how she's able to keep that one little piece so extra blonde or whatever. Hey, Lori, let us know. We're kind of curious. Oh, hey, Sprinkled Donut. Sprinkled Donut is sneaking at work. But here's my thing with the medication. Okay, I do think that she does have some form of mental illness. What that mental illness is, I do not know. But whatever it is, she's not taking medication for it. So it does make me curious as to all the like, are we wrong? Are we thinking that there is a mental health situation going on, but there's not a mental health situation going on, and which I just, because she's not on anything, and that kind of, makes me like, "What?" Alright, here we go.
Are you currently prescribed any medications in the jail?
No.
Do you believe you're able to present a defense at trial?
I do.
Are you able to listen to what the court, counsel, and witnesses say during trial?
Yes, I will.
Do you believe you're able to ask witnesses
I
questions that are
wish I knew
relevant to
what
the
that
case and to your
alert was
defense?
for, because I
Absolutely.
can't see
Are
anything.
you able to communicate effectively, do you believe, with the court, counsel, opposing counsel, and the jury?
I do.
I will make a finding that in court, you do appear to act appropriately, speak appropriately, and communicate appropriately. Have you ever represented yourself before?
Not yet.
I do have a waiver form, one for each of your cases. You've gone over that waiver form with
And that's another thing. Okay, so you hear that there was some, um so, okay, badgered witness says she might just refuse because she doesn't think there's anything wrong and she's not necessarily a danger to herself or others while in custody, so they probably can't make her. I thought the same thing until the judge asked her if she's been prescribed anything in the jail, and she's not. So there's a difference there. If she were, evaluated in prison in Idaho, right? And they found that she had something that required anything, frankly, that required medication, whether that medication be something for mental health or some other type of medication. Um, she I feel like that would be noted. I feel like there would be a distinction made between, but maybe I'm wrong, as true psych ward, let's ask her. True psych ward says she can refuse mental health or psychiatric services, which, yeah, um, but he asked if she was prescribed anything. Let's rewind it in here because I'm curious. I feel like that if we're talking about a scenario where she's about to represent herself, um, I feel like that's important. There's a distinction between I'm not taking anything because I'm refusing it, and I'm not taking anything because I'm not prescribed anything. I don't know. I just feel like that's important, an important distinction. All right, hold on a second. All right, here we go.
the last 24 hours.
No.
Are you currently prescribed any medications in the jail?
No.
Do you believe you're able to present a defense at trial?
I do.
Are you able to listen to what the court, counsel, and witnesses say during trial?
Yes, I will.
Do you believe you're able to ask
Okay, well then that makes sense. True Psych Ward says if she refuses medication, she will not be prescribed any. Now, Shaggy says, imagine her cross-examining her ex-bud Melanie. That I'd like to see. That is exactly what I'd like to see. That is the um as okay, so let's get to back to this. So True Psych Ward says, psychiatrists can ask her if she wants to start a low dose trial of meds, and she can say no, and that would be the end of it. Okay, well, that makes sense. That makes sense. Um, I don't understand what that dadgum. Hold on a second. Why is this doing this? Just continuing to go off. It's driving me nuts. Is it doing it for you guys too? It's driving me nuts. Alice, hold on a second. All right. So, anyway, let's just moving on from that. That's going to drive me nuts. I can't figure out what it is. It's driving me nuts. Anyway, can you imagine if it comes down to it and she is going to cross, if she gets up there to cross-examine Mel G? Remember when they were calling each other hoes in Bible? I wonder if it's going to be like that. Oh, God. All right, here we go.
Witnesses questions that are relevant to the case and to your defense.
Absolutely.
Are you able to communicate effectively, do you believe, with the court, counsel, opposing counsel, and the jury?
I do.
I will make a finding that in court you do appear to act appropriately, speak appropriately, and communicate appropriately. Have you ever represented yourself before?
Not yet.
I do have a waiver form, one for each of your cases. You've gone over that waiver form with your attorneys.
I did.
You understand the waiver forms.
I did.
You have the right to an attorney. If you can't afford an attorney, I would appoint one to represent you. The attorney would represent you at all critical stages of the case, including before trial, at trial, and if you're found guilty at sentencing. Do you understand that?
I do.
So Dr. B says, I believe she suffers from delusional disorder. Many people in this group lack insight into their mental illness, and delusions are medication resistant. I love your insights, Dr. B. Please don't ever stop giving them, because I don't understand some of the nuances. That's not my area of at all, any way type of insight or expertise. It's not something I'm really familiar with. So I'm glad that you're explaining this to us. I just cannot see how she is going to represent herself in 2 trials. I just really Tobins, good to see you. Tobin says, Ward case studies, I've missed you. I'm late. Hope everything is going well. It's going good. It's going good. So yeah. Yeah. All right, here we go. Let's keep going.
An attorney can be of great value and assistance in criminal cases. There are serious disadvantages and dangers to representing yourself. Can you just tell me a little bit why you want to represent yourself?
Yes, Your Honor. For the past 5 years that I've been incarcerated, I have taken upon myself to study case law and criminal rules of procedure in the state of Idaho and Arizona, as well as federally. Prior to that, for the last 10 years, prior to my incarceration, I did study procedure in family law, and I have real trial experience. I have participated in 3 different full trials from beginning to end.
Wait a minute. First, let me say this. Thank you, Shaggy, for becoming a member. Thank you for supporting me in the channel. Welcome to the ward. Okay. All right. Lori. What 3 trials have you participated in, ma'am? I mean, I know your criminal trial. I'm assuming these others were family court trials, because civil court and criminal court, not the same. Not the same. So I'm going to need you to, are these actual trials that actually happened, or are these trials that exist in your brain only? The same brain that thought this hairdo was a good idea. That brain. All right, here we go.
In family court?
1 in family court, 2 in criminal court, 1 bench trial and 1 jury trial.
Okay.
Were you a juror or something?
You understand that you have 2 separate cases here. On each of these cases, if you're found guilty at trial, you'd be facing a sentence of up to life in prison with the possibility of parole after 25 years?
Yes, I'm well aware of that.
And you understand that if convicted at trial, that those sentences could run consecutively or concurrently to any other sentence?
I am also well aware of that.
All right.
Oh, okay, Lori. Well aware.
You understand that if you represent yourself, you'll have the sole responsibility for, among other things, asserting legal defenses, interviewing witnesses, doing investigation, doing legal research, filing and arguing motions, examining and cross-examining witnesses, giving an opening statement and a final argument to the jury. Do you understand all that?
Yes, Your Honor, and I'm very prepared.
All right. Do you also understand that you'd be held to the same standard as an attorney regarding the presentation of your case?
Lori, I don't care for ras fat kneecap what you say. There's no effing way that you're prepared. Stop it. Stop. No, she's not. She's not, because I'm not exactly sure. Now, Arizona has it, but her charge is conspiracy to murder. That's related to Charles Vallow, and then she's facing attempted murder in the as it relates to Brandon Bordeaux. So, yeah, Bordeaux. So, I guess not. Me too. I like it when he does this too. I like it when he explains, this is going to be an absolute shit show. This is what's likely going to happen. This is how I see it. I think that at the end of the day, what Lori wants to do, maybe she wants to take a couple of swipes at old Mel G. Okay. Because there is something brewing there. And I intended to talk about it a while back. And I got sidetracked by gosh only knows what. It could have been anything and nothing at the same time. It literally could have been maybe we got Letitia calls in, which would be actually something, or it could have been I saw something shiny, or I got unlimited lives on Matchington Mansion and just forgot to schedule the live. But there's some type of immunity. There was some type of immunity discussion that occurred like maybe 5 hearings back. And I intended to talk about it, but like I said, I got distracted by it's not conspiracy. I'm going to have to go back and redo all of this thing. Okay. Thank you, Trace, on the case. I appreciate that. All right, let's keep listening. But yeah, there's something there, and I want to talk about it. But I'm kind of curious because Lori has this option. So Lori her standby counsel will be there with her in court, and she can change her mind and ask them to then become her attorney of record. So I'm kind of wondering if she just wants to ask Mel G some questions that maybe she feels should have been asked of Mel G at her trial, but weren't. Maybe that's her play. I don't know.
This would include knowledge of courtroom procedure, applicable case law, rules of evidence, and rules of procedure.
Yes.
All right. Each of your attorneys have gone to college, undergrad degree for probably a minimum of 4 years, and then law school for an additional 3 years. So these 2 attorneys that are here in court each have, at a minimum, if not more, 14 years of higher education, as well as probably, I'm guessing, between the 2 of them, 30 to 40 years in trial experience. Do you understand that?
Yes.
Yeah, I don't care. That's what she's saying.
Do you understand that your case may be specifically complicated in the sense that there are complicated evidentiary issues in your case? Do you believe you're able to present a defense?
Yes, I'm well aware of them.
Yep, I'm aware and I don't care. Can I just make this is just this, let me do it correctly. We're on Judge Bev's sidebar real quick. I have never noticed 2 people who have just absolute perfect posture. Boone and Lori over here. Boone sat exactly the way that Lori is seating. It's it's hard to sit up straight. Maybe it's just me. When, without the use of the back of the chair, but Boone and Lori can do it and they don't just do it for a short period of time. That's how they sit. I can't sit like that. It's just something I noticed. Wonder if there's studies being done about like evil people and posture.
All right.
Something to think about.
Do you also understand that if at some point,
Yes, Ruby Frankie
especially if you're
too.
in the middle of trial, you decide that you would like your attorneys to take over the case, you'd be effectively waiving any ineffective assistance of counsel claim that you might have because they might like a longer time to prepare?
Correct.
All right. Do you understand that even if I may allow you to represent yourself, I'll be appointing these attorneys to represent you as advisory counsel?
That's my understanding.
All right. If you want to testify at trial, you'd not be able to testify in a narrative format. Instead, you'd need to write out the questions, and the advisory counsels would ask you questions when you testify.
Yes, that's what I'm aware of.
All right. You can change your mind about this at any time. If at any time you want to be represented by your advisor.
Okay, hold on. Shaggy says, I'm going to go back and watch the video of her and Mel G at the police department concerning Charles. Yes. And as it gets closer to her trial time, I will absolutely, definitely 11 billion% be going back and doing the exact same thing because there's a lot there and it's been a long time and I need a refresher. And frankly, although the subject matter is not funny at all, poor Charles, he, bless his heart. He was worried and it's just awful. But there are things that Lori and Mel G say in that interview that are just, there's no other way for me to say it, but they're so ridiculous that I have to make fun of them. I can't help it. All right, here we go.
Advisory counsel, let me know. I will appoint them back to represent you as your attorneys of record. But once you make the choice to have the lawyer represent you again, I wouldn't allow you to switch back and forth. Do you understand that as well?
Correct.
You also understand that if you ask your advisory counsel to take the case back over in full, you wouldn't be able to repeat anything that had already happened in the case or do over.
Correct.
All right.
No mulligans.
Because you'll be acting as your own attorney, you'd be expected to appear for every court hearing and every day of trial. If you do not appear for hearings or trial without good cause, I could consider your non-appearance to be an indication that you want to withdraw your right to represent yourself, and I would order your advisory counsel to become your attorney. Do you understand that as well?
Sure.
Your right to represent yourself is not absolute, and what I mean by that is if you fail to follow procedures, if you don't act appropriate in the courtroom, your right to represent yourself could be revoked. Do you understand that as well?
I do understand that.
All right. Do you have any questions about anything?
I just was going to ask if we were going to move forward from this today and if we are going to be able to reset trial.
We will.
Okay.
All right. I did receive your form. Is this your signature at the bottom of each form?
It is?
And I think I already asked you this, but I'll ask you it again. Your signature appears on this form after you went over it completely with your attorney?
Correct.
All right. The court finds your waiver to an attorney is knowingly, intelligently, voluntarily made. I guess I should ask you, did anyone force you or threaten you to waive your right to an attorney?
No, quite the opposite.
Did anyone promise you anything in order to get you to waive your right to an attorney?
No.
All right. I do find your waiver is to knowingly, intelligently, voluntarily made. Your waiver is accepted and entered of record. You will be your own attorney on the case. I will keep these attorneys on as your advisory counsel. Again, if you change your mind and would like them to take over the case, you need to let me know, okay?
Okay.
Your current last day is May 11. I'm assuming you want to set a trial date within that last day?
Yes, I do.
All right, we're going to set a trial date March 31st for jury selection at 8:30 a.m. Well, we'll set it at, for now, 9 a.m. That could change the time, but we'll keep the date, March 31st. I'm going to, can I ask advisory counsel, in the event that she wishes to conduct interviews, would you be assisting her in that, or would your office have an investigator that would assist?
Either or.
Yeah,
Go ahead.
I think generally OPDS will assign an investigator for that purpose, and we would ask the court to endorse OPDS on this minute, first minute entry.
All right, the court will appoint.
Look at Lori shaking her head yes, as if she actually knows what they're talking about. She doesn't. Cut it out. All right. So yes, Boone's toilet hooch. I concur. Absolutely, without a doubt. Yes. Yes. Call Ned Snyder to the stand and see what happens. I agree. All right. Uh-oh. All right, here we go. I think that's good. I think we got it. Right, you guys? All right, here we go. Let me share this for you guys right quick. Here we go. Now we're on to Boone. Now, y'all, this is 28 pages. Okay? Yeah, 28 pages. Let me make this bigger for my ability to read. All right. Are we ready? Can everybody hear me? All right. All right. Now, before we start, hold on a second.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash! Yeah.
All right. Make sure that you help your girl thumbs up the stream. All right. Are we ready? I didn't either. This was a last minute situation. The chat told me about it and KPM emailed me about it. So I'm super excited. All right, here we go. December 6th, 2024. Oh, now she's not now she no longer addresses him as the judge. Now she addresses him as Mr. Michael Kranick. I am enclosing, please, my complete statement to you and the world as I partially read during my sentencing hearing. By my reserving particular parts of my very true and meaningful statement, I was hoping to have been graced with your forgiveness, understanding, and consideration in any level or degree. For me, unfortunately, and regardless of whom I had speak on my behalf, or the number of your ignorant mind, was already made up. By your clear error and full-blown unfair bias against me since your involvement in my crucial case as a whole, I have been unsuccessful in receiving anything from you as a supposed fair and neutral judge, except for your wish that I spend the rest of my life in prison. Please know and always remember, Mr. Kranick, I forgive you, still and sincerely. Please understand also the judge, according to Cicero, is never to lose sight that he is simply a man and that he cannot exceed the power given to him by his commission, that not only power but public confidence has been given to him, that he ought always very seriously to attend not to his wishes but to the requisitions of law, of justice, and religion. I am excited in my appeal, which speaks for itself. My case law as well, in which I am extremely proud to have achieved and will continue doing so now that I am no longer in your corrupt court and free from your malevolent judicial grip. Sarah Boone versus State of Florida. I also have added to my statement as a result of your blindness and impartiality, foremost your disgust in me as being an outspoken woman, determined, dependent, and proactive client. hoping the next time you put on your listening ears and do not unfairly oppress the next as you have so blatantly done me. You will never admit your many judicial errors, nor will the prosecutors theirs. And I will never admit to what you have wrongfully accused me and judged me as. I am not a murderer. I am a survivor. Sarah Boone. Oh my God, you guys, it's not getting any better. How am I doing so far? Okay, here we go. Black robe disease, arrogance in a judge, a slang term for a judge who flaunts judicial power and dominates proceedings at the expense of the dispensation of justice. Impartiality is the first duty of a judge. Before he gives an opinion or sits in judgment in a cause, he ought to be certain and absolute that he has no bias or for or against either of the parties. If he has any interest, even in the least slightest in the cause, he is disqualified from sitting as a judge, and when aware of such interest, ought to lawfully and justly refuse to sit on a case. The delicacy which characterizes the judge in their country generally forbids their sitting in such a cause. The judge must not only be impartial, but also follow and properly enforce the law, not abuse. He is bound to declare what law is and not make it be on an arbitrator, but an interpreter of the law. It is their duty to be patient in the investigation of the case, understand circumstances and difficulties by all parties, careful in considering parts of a case in a whole, and decent in judgment. Bouvier Law Dictionary, 2012 edition. But at the risk of practicing judicial cynicism, a word I have coined in this presentation, others have called black robe disease. Whether he was correct or not in my behavior, it is widely accepted that judicial behavior affects the jury. And then there is the worst of judicial ailments, the black robe disease, which is otherwise known as arrogance. Oh my God. Trial judges are affirmatively charged with securing a fair trial and must, sorry, you guys, and must intervene as a spont to what end when necessary. That duty encompasses not only the avoidance of error before it occurs, but the fair correction of error that may have occurred earlier in a proceeding. In the instant case, the trial judge did not analyze the evidence, he added to it, dealing with a mere mannerism of the accessed in giving his accused, I think is what she wrote there, accused in giving his testimony. The judge put in his own experience with all the weight that could be attached to it in the scale against the accused. Kintsukuroi is a kind of Japanese. Now we're to it, all right? And I'm probably not pronouncing this word correctly, and I'm sorry. Kintsukuroi is a kind of Japanese ceramic style, which means to repair with gold. In this tradition, when a ceramic piece breaks, an artisan will fuse the pieces back together again using liquid gold or gold dust lacquer. So rather than being covered up, the breaks become more obvious and a brilliant new piece of art emerges from brokenness. It embraces flaws, weaknesses, and imperfections, and also teaches the essence of resilience. Every crack in a ceramic piece is part of its history, and each piece becomes more beautiful because it has been broken. This is the wisdom of Kintsukuroi. Sincuri is probably, I think, how you say it. In my wisdom, and with all my repairs then, now, and ongoing, God is, has been, and will always be my artisan. All of my gold is forgiveness. This has held me together, made me shine brighter, and overcome the damage caused by George Torres, the Torres family, the justice system, Judge Wooten and Cranick, Orange County Corrections Department, social media, scoundrel detectives, infamy, defamation, ongoing constitutional rights violations, second-degree murder, forced into being pro se. Just as gold is very precious, forgiveness is invaluable. Somehow we're missing a page. Skipped. Hold on. Let me find page 2. Forgiveness is not an attempt to change or forget who, what, or how you've lived through to be so gold, but an act of grace, humility, and considerable self-compassion to be set free from so now. Withholding forgiveness denies your brilliance and adds even greater grief and deeper heartache, irreparable cracks on top of the already that no one deserves, no matter the pain or disappointment, untruths, or injustice. It doesn't matter, as the more broken you are, even though now different than before, you've become more outstanding and more extraordinary. Above all, when you let go of blame, which you clearly haven't let go of because you just blamed everybody, misunderstandings, excuses, give up your anger and cease from resentment. This is forgiveness. And when you forgive, you heal. And when you heal, you move forward. Okay, Sarah is Yoda now. Fear leads to hate, hate leads to anger, anger leads to suffering. My gold begins with George Torres and every time he slapped me, kicked, punched, spit on, raped, stabbed, choked, laughed at, pushed, pulled, dragged, whipped, tripped, stole from, lied, terrorized, threatened, humiliated, forced, degraded, made me cry. Every time he tried to end me, defeat, or destroy, I forgive George for beating me senseless. Hold on, I missed that part. For trying to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions, and keepsakes, my son's furniture, destroying the television we watched together. We saw that video. Sarah cut it out. For wrecking our townhome by breaking windows, punching holes in the walls and doors, or ramming his entire body into glass doors, kicking in my front and back door over and over and over. For breaking or removing the locks from all the doors and sometimes the knobs altogether, so I had nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed. For terrorizing and threatening my blind and deaf dogs by leaving the gate open I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond or scrape their remains off of the pavement, for kicking them off the bed and throwing across the room because they were trying to protect me, for threatening to make me unrecognizable to my son by breaking all the bones in my face like his brother Moses did to him after he kept seeing all the bruises, scroll, 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 from George beating me, like all the times their father beat their mother. Shut up, Sarah. For all the drunken rages and fistfights with so many neighbors when wandering into their apartment during hunting expeditions after I escaped. For drowning me in liquor and wine because I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face, giving me 2 black eyes and a bloody nose. For making me experience what it is to be, I'm not reading that word, threatening to kill my friends and the neighbors when they checked on me to make sure I was alive and in one piece, for threatening to burn down our townhouse and to set my car on fire because I got a job, for holding me hostage on weekends. My son was supposed to come over by keeping my keys around his neck, my phone in his crotch, and butcher knife stuck in the middle of the tables as a warning to not to ask anything or try to leave, for stabbing me in the leg and not letting me call 911 for an ambulance or seek help, where I nearly bled to death, though I needed no transfusions. And they pretty much sent me home the same day, until I concocted a lie to save him from being arrested, for destroying my phone with a hammer because my son called, for me experiencing ever being arrested and after today, prison, for beating me almost blind, crushing my occipital lobe, all things that there's no proof of, for having me experience what it means to see stars like the cartoons where the character has a tall lump on their head. I had that too, many times, dragging me downstairs by my hair in the middle of the night just to sit next to him, for taking my car, driving drunk with my debit card to buy more alcohol while I slept, even after I kindly explained the importance of my car to take my son to school foremost, me to work, and he to his batterers intervention classes and probation officer meetings where I would be forced to sit for hours in the parking lot waiting for him, which is also not true, for causing me so much trauma and pain mentally, physically, emotionally. I had to be hospitalized more than once. Sarah, we saw the videos, your videos, or videos you recorded, the videos that you say are evidence of George being atrocious to you. And actually, it shows the opposite. How are you guys doing over here in the chats? You guys doing okay? Good. All right. Bruh, this is all right. Brace yourselves. For destroying my reputation and integrity, for my M for murderer scarlet letter, not letting me feel safe to live, talk to other people, spend time with my son, have a job, friendships, simply go to the bathroom when the door with the door closed, or go to sleep soundly or comfortably. I'm going to stop you right there. Okay? Because I feel like if it was George that stopped Sarah from having friendships, yes, those friends would be obviously not in Sarah's life at the time that she was with George. But I do feel like if she had actual friends, they would have rushed to speak for her at her sentencing hearing to tell the judge the things that they witnessed and how George kept her isolated. And did that happen? No, it did not. Moving on. I forgive George for lying, for him trying so many times to end me with his terrifying love. I also forgive the Torres family, his mother and father foremost, also his 2 ex-wives and daughters, all for knowing who George was capable of and has done in the past, his history of violence and where he learned it, then to keep turning a blind eye when I would ask for help. All of his siblings, including Farrell Torres, who is now on his way to prison for stabbing the mother of their baby in the side of her head, for everyone who knew what George was doing to me, sometimes how and when, but allowed and enabled. I forgive them for caring too late. I hope they all ask themselves, while quiet and comfortable in bed at night, the uneasy question: what could I have done to stop this from happening to both of them? And after all the time Sarah tried to by asking for help from all of us and so many times. Here we go. This is for us, you guys. Now, this part she did read, so we're familiar with this. Let's see. All about the social media. Blah, 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 blah. Oh, my God. Oh, social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. my criminal case as a result, my opportunities to be given a fair, proper, and uninfluenced, successful conclusion. I thought it was successful as AF, Sarah. I thought the trial and the conclusion was successful AF. And I'm saying that in all caps and bold font. Poppins bold, if you want to know. Extra bold, if you want to know. Bruh. I forgive them. Also, all the media tycoons for not having a life of their own, trying so desperately to make themselves seem so right by making me appear so wrong. Forgiveness for every prejudgment, ridiculous theatrics, lies, making and taking blood money from my and others' misfortunes, accidents, and catastrophes. It's all over their hands and keyboards. And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed in my case, still, no one knows me. Yeah, I'm pretty sure we know you, Sarah Boone, and you're terrible. My gold also runs deep for my prior attorneys. Mauricia Padilla, who sold me the world with empty promises, then abandoned his responsibilities as new attorney after taking 2.5 years of my life, when finally realizing he was in over his head, all while hoarding JAC dollars to fund his staycations with his family when in town from Miami, for having resources ready and available, not allowing me, the client, to ever utilize, which could have greatly progressed my case and perhaps concluded, only for him to decide water parks, fine dining, and choice hotels were more important, and on the JAC's dime. Okay, Frank J. Bankowitz, this one's for you, bud, as if she hasn't said enough to you and about you. This is what was redacted. I forgive Frank J. Bankowitz for committing perjury to the judge and on court record about my attempts to be a proactive defendant and client, inquiring about my discovery, then trying to communicate with no answer or correspondence in any manner for 1 full year and 2 months before I was able to finally meet with him in the courtroom, only to receive his motion to withdraw. Double M, thank you. I appreciate that, babe. Thank you so much. Thank you. That was super generous. Hold on, let me highlight that. Thank you so much. Look here, Boone. Haven't you done enough to freaking get to Mr. Bankowitz, to all of your attorneys, except for you, Owens? You knew what you were getting into. All right, here we go. Frank J. Bankowitz is forgiven for his greed in taking $15,000 from the JAC, who honorably aid indigent defendants as myself, for taking advantage of and robbing the justice system by lying and avoiding clients, taking their money and the JAC's. Mr. Hobson, this one's for you. Winston E. Hobson receives my forgiveness, who also unethically perjured himself to the judge and on court record about all the progress for his allegations of my supposed unethical requests, which meant me asking about my discovery and trying to have him file a motion for my lawful inclusion to my pretrial conferences cited under FRCP Discovery Rule 3.220. I wanted to be included in my case, and no progress from being excluded by Bankowitz and Padilla over 3 years prior. Forgiveness also in telling me he would return in a week with my discovery, only to receive his motion to withdraw in the meantime. Still not receiving my discovery, and I filing my own motion asking me to go to all my hearings, including my pretrials. Continued forgiveness in his greed and selfish intentions, also for robbing the JAC and indigent defendants of $15,000 more for nothing, justifying any work he really did do in the handful of days he represented me as my attorney. Finally, and with all my gold received from this one, I forgive Patricia A. Cashman for her mean, snotty, egotistical attitude and not listening or caring that I finally received my discovery. I kept asking for her for, which she fully withheld from me, citing her ridiculous, untrue reasons, was because I saw with my first attorney 4 years prior, and while she is being my present at the time attorney, I saw not one page of or any digital evidence of my discovery she prohibited me from seeing. Patricia A. Cashman is also forgiven for admitting I had a right to a bond I asked her for, so I could actually utilize one of my rights as opposed to having them always violated as prior and still ongoing. Then her deterrence of all my opportunities to do so, for all her lies, condescension, gross, unnecessary arguments, and anger that I asked any questions and wanted to understand, for her doing nothing other than giving me an even harder time and request transcripts, then brazenly lie for over $16,000 for doing so. Also from the precious resources provided from the JAC. I forgive Patricia A. Cashman for being a liar and a bully. Forgiveness for all those who did not include me to receive my $15,000 share I worked for when Judge Cranick forced me to be my own attorney to represent myself pro se. Guys, she wants $15,000 for representing herself. Oh my God. Oh, Sarah, well, not me any longer, but the entire time that you were receiving a roof over your head and 3 hots and a cot out over there in the Orange County Corrections Department, myself, along with all of the taxpayers of Florida, we're footing your bill. You're done. We're not going to give you 15 grand for representing yourself because you can't act right. Sorry, not sorry. I actually and finally got my own discovery almost 5 years later. Filed motions all prior should have done, making them the most expensive motions ever at over $46,000 between the 3 prior attorneys, Frank J. Bankowitz, Walter E. Hobson, Patricia A. Cashman. Would they have done so when supposedly representing me? The motions would have been priceless for the proper use of the JAC funds for word ethics, professionalism, honesty, and freedom. I honorably utilize my JAC resources and mentorships as a proactive indigent defendant, avidly defending myself against the liars, thieves, and real villains in my criminal case. Who really is the criminal? Still you, Sarah. You are still the criminal. The JAC can hopefully include their forgiveness for them also. Judge Wooten and Judge Cranick, I have great forgiveness for also in not protecting me and listening to my valid requests for judicial intervention so I could properly and fairly defend myself against my charges. Instead, I had to defend myself. We're only halfway through, you guys. Wait, no, we're a little more than halfway through. We got 12 more to go. My bad. So I could properly, fairly defend myself against my charges. Instead, I had to defend myself against the attorneys, all appointed by the judge in court, against their lies and exaggerations, reasons unjustifiable why they were really creeping away from the battlefield and abandoning their professional duty as my attorney. No, Sarah, they didn't lie. Let's be honest here. What you wanted them to do was to say things that they could not say. You wanted them to mount a defense they knew wasn't true, and they felt ethically you don't qualify for the battered spouse defense, and they felt that you're not, that because of, it's not that you weren't not that you weren't battered, and that maybe that you are a battered spouse, but because of the circumstances surrounding your case, the actual events of the case, you do not qualify for the battered spouse defense. And they felt that it would be unethical for them to mount such a defense. You need to stop playing. Okay, Judge Kranick, sir, this is for you. Judge Kranick, I forgive you for not giving me any opportunity to stand at your pulpit, to stand at all, to explain the real, truthful side of the story. I believe if the justice system, including yourself, would and should have done any vital homework on the already almost see-through attorneys from being spread so thin and simply sending an email to care about their present workloads, number of clients, trial schedules already in place before throwing another inmate defendant unknowing client on the heaping unimportant pile of warm bodies, more taxpayer dollars could be conserved and less time consumed and wasted for everyone, regardless of what part they play in the supposed system of justice. My forgiveness is deepened for taking even greater time of mine away, years, by not caring to ask me anything about anything to understand so you could justifully render your life-defining judgments and withhold any more bias and prejudice. Foremost, Mr. Judge Kranick, you need to know that your forgiveness is secondary to, no, I misunderstood. Right, let me see. Yeah, it's still going on with Judge Kranick. My bad. I thought we were getting to Judge Wooten. Foremost, Judge Kranick, I forgive you for kicking me when I was down and choking the life out of my constitutional amendments. Most profoundly, my sixth right to counsel, as a result of my wholehearted use of my first right to free speech in being my own advocate, since no one else would be, and received a paycheck for. In all my free speech experience-driven letters, only for remedy in any collaboration, inclusion, receiving my discovery as an inmate, defendant, and client, not removal of any attorneys to cause more delays or any reason or excuse you may try to force on me and have already inappropriately accused me of doing prior with your heavily insinuated strategies of mine to try and deflect the glaring red flags, disappointments, and true crime in and out of the justice system. To this day and all forward, I do not forfeit my rights, any of them ever, especially my right to be bold, outspoken, and right in my real life experiences with the legal and justice systems. You weren't there, Judge Kranick, in anything, no meetings, phone calls, visits, and still took my rights and oppressed harder. I must now defend myself against you, praying you do not care too late as all the others and retaliate further against me as a still proud citizen of the United States of my America and freely, excitedly using my God given rights to still try and defend myself, to stand all the way up for you to remove my freedom altogether by allowing and improving my stab wound, bloody body parts, essays, bumps, bruises, and all the rest of the beatings I endured. I hope you can finally see and understand just some of the pain from the extreme difficulties, obstacles, and unfairness, especially in my due process. You have added in my criminal case and life as an inmate, defendant, and client. All is forgiven. For Detectives Capsule and Lowen, I forgive their demoralization, lies, blacklisting, coercion, law breaking, solicitation of my case before I even arrived at the corrections department to be booked and fingerprinted. This can be seen in my unbeknownst interrogation video where I ask what they are doing, what all the pinging was doing during their texting swarm while I naively sit there waiting to be arrested, which they know would happen the day before. For Kepso, for bald face lying on the stand to the judge in court on record, she didn't tell me to come to the station to pick up my phone. Why else would I go? I didn't even know about the surprise interrogation. I forgive them all for also lying how the news showed up to record my walk of shame, handcuffed and confused on camera. I forgive them for trying to make me lose from the beginning. I forgive them for trying to make me lose from the beginning by stating the unquenchable wildfire of starting the unquenchable wildfire of sensationalism and distortion, ignorant hate, defamation, and greed by unlawfully broadcasting who they wanted they would to think I was by their schemes, learned lessons and fraudulent stratagems from the school of manipulation and taking advantage. How much did they make off of me and still are for calling it in, then removing the curtain to expose their personally twisted, murdering monster? Also, my forgiveness and greater gold comes from wondering why nothing viable in my defense was taken from my townhouse. AKA the crime scene, to aid in my truth, such as the butcher knife, 5-prong garden claw, or hammer under the table together outside where George had easy access for use if I tried to leave or call for help while being held against my will during his rageful binges, or my bloody pillowcase stained from me being backhanded because I hid the magnum-sized bottle of vodka from him. Why weren't any crime scene photos taken of holes patched in walls and doors, some doors missing knobs and all locks? George removed cracked windows, broken furniture, obvious unnatural destruction in my townhome. How and why were these missed, uncared about, or not questioned so I could explain some things of my terror or explain some of my terror? It makes no difference. All is forgiven. Prosecutors Mr. J and Mr. Cacciatore, my forgiveness is also extended for your inappropriate attributed narratives, for having to go through years of my pictures, videos, texts to erroneously piece together your deceitful, damning version of what really happened and who I am. After so much availability and for so long, you were finally able to make the circle fit into the square. I forgive your antics, theatricals, ludicrous. What? Ludicrous comments to make sure the world got their money's worth while watching with ignorant pitchforks and burning torches hoping for the best from you, which is my worst. Instead of dropping the mic, Mr. J, you dropped the bat. For the yelling, finger pointing, and intense underlining to force your theatricals and fantastics on the jury by using imaginary space adventures and fictional characters to blind and bedazzle them with your far, far away from the truth dramatizations. Now, look here, Sarah Boone. What we're not fixing to do is talk about Star Wars like that. Okay? That is not happening. What he was doing is what we call a metaphor. Come on, you excel at everything. You're the smartest person in every room all the time. In all of your pieced together productions, I forgive you most for never seeing the light in people, the light in people, their human goodness, humor, and big hearts. You wake up to seek out the opposite, to condemn, to take lives in your own way. See the good that does exist in all of us, inherently and unforced, even as the proud Mr. J stated, the kicked dog that bites. Mr. J, who kicked the dog in the first place? In my wisdom, it's usually best to leave sleeping dogs lie. Then they don't bite. That's true, Sarah. That's true. Because you are the sleeping dog and you do bite. My gold goes out to the jury for not understanding my cracks, from being blinded from the injustice and malpractice in all of the judicial and prosecutorial errors, the very apparent violations of my constitutional rights during my case entire trial, which caused mass confusion and dysfunction. No, ma'am. No. They weren't confused. They saw it. I forgive the jury truly for being weary from this confusion and dysfunction, also from being hungry and tired and wanting to go home to their families after being away in full capacity for 2 full weeks. I understand. From this and their brash, misguided, corrupted decision, I was wrongfully judged a murderer instead of a survivor. For this, all is forgiven. For this, I can still survive and stand tall, having an even greater, the greatest opportunity to finally be understood in the Supreme Court for my appeal. They ain't finna hear that. I didn't lose. God just wanted me to win in a different way. Freedom and forgiveness with a heart. Yeah, she already read this. Forgiving herself. I forgive myself. Why don't why don't you go forgive yourself? We read this already. My apology is profuse and ceaseless. Let me see. In my soft-spoken conclusion. Shut up, Sarah Boone. She read all that. All right, you guys. Wow. I think we need a little something of a palate cleanser because this is too much. Hold on, let's see. Let me find it. Give me just a sec. I think it's right here. Hold on. It's taking a moment to load. Give it a second, you guys. I cannot believe she thinks she's entitled to $15,000 for representing herself. Shut up, Sarah. All right, here.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
Okay. So, yeah. Sarah, I mean, look, I can see why Owens was like, maybe don't say those things. Maybe that's not the best approach. Maybe leave some of this out. Uh, my stream is behind. Give me just a second. That's what I'm saying, Carolina. How are you going to talk bad about Star Wars? Okay, just because you didn't understand the metaphor, Sarah, doesn't mean it wasn't a good metaphor. Yikes. All right, you guys. So that is pretty much that's all I got for you guys tonight. Tomorrow I will be live again, 8 a.m. Central Standard Time, 9 a.m. Eastern Standard Time. We're going to listen to the sentencing of Chloe Driver because I'm very curious what she's going to get and how it's going to work. I've not seen a jury reach that conclusion before, and so I'm very, very interested to hear that. So I want to thank you guys all so very much for being here tonight. I'm just going to drop my links one more time. Also, the other link that I want to drop is Nay's link because she has the best wax melts on the entire planet. And we're getting into, it's Christmas is upon us. And if you've got like an office gift exchange and you don't know the person, or hell, if you have like a new family member, like somebody's, bringing their boyfriend or their girlfriend to the family Christmas or whatever, and you're not sure of a gift, everybody likes a good smelling home. So check out Nay's. I think that you guys will really, really love it. Okay, Lil Red, it's cool. But I'll be back tomorrow morning. Okay, you guys. If you can, please give your girl a thumbs up on the stream. I would greatly appreciate it. Again, thank you. Yes, or send them all to me or Little Red. Not okay. Obviously, if you're sending them all, that won't work. So send half to Little Red and send half to me because I cannot get enough of Nady's wax melts. You guys have a great rest of your evening, and I will see you tomorrow morning. All right. You guys have a great night. Take it easy. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious.
Minutes later.
all do a little math sometimes.